We are back to give you the legal edge. With the school year coming to an end, many parents might be enrolling their kids in sports and other activities over the summer, and those sometimes come with liability waivers. Here to talk about whether those agreements are enforceable is local attorney Brian Waldman.
In Michigan, these liability releases or waivers that parents commonly sign are enforceable, but only under limited circumstances. And those circumstances are that the entity being released has to be both a non-governmental and nonprofit entity. And the liability being released can only be for risks that are inherent in the sport or activity. So what does that mean, a risk that's inherent in the sport of it or activity? It's the type of thing that you would expect to encounter just by the nature of the activity. For example, being hit by a ball, running into another player, running into a fence or a goalpost, the types of things that simply cannot be avoided. They're part of the sport or activity and things that we're accustomed to being exposed to just because of the nature of the activity. Now, it doesn't mean that for-profit companies or other entities, governmental entities, aren't having parents sign releases. And parents often sign those releases because the choice is you sign it and your child plays or participates, or you don't sign it and they can't play and participate. There's no negotiation of these types of contracts. So as lawyers, we often look at these contracts after the fact. We then determine whether or not they're enforceable under the law. And under Michigan law, unless the entity being released is non-governmental, nonprofit company, only releasing risks inherent in the sport, when it comes to releases for minors, they're not enforceable.